All rise. The Lawyer of the Apes is now in session. Hey guys, how's it going today? So I originally had done a video and then I was about to publicize it, but then in the end, I went back and I decided to update this video because of a letter that I saw floating around on the internet regarding defamation from Citadel. So I wanted to include that in this video. So this video will deal with Rule 12B, credibility and defamation. So let's start off with defamation. So I was on Twitter and I saw that another Twitter member, Kat Stryker, who's been really important in the ape community, posted a letter regarding one of her planes that were going to be going up in the air, and the plane was going to carry a banner that said, "Ken Griffin lied under oath." Now, that company, Fly Signs Aerial Advertising, received a letter from a law office representing Ken Griffin and Citadel, and basically saying in the letter that if they flew the plane with that statement on it, they would be going after them for defamation, a defamation claim. Now, the interesting thing is that, of course, they went after the company, because usually when you go after someone for a defamation claim, you always go after the deep pocket. I'm not sure what Ms. Stryker's financial background is, but they usually go after the corporations because they're the deeper pocket. So that's why they would go after them for this case, and rather than the individual. But that's usually, the case when it comes to a situation like this. So they made an allegation that that statement, "Ken Griffin lied under oath," would be considered defamation. Now, they're not wrong about that. And I'm going to show you guys why. So basically defamation, right? Defamation, it can come in two forms. There's two forms of defamation. There's slander, which is the spoken word, and written, which is libel. So those are both forms of defamation. Now, there's general defamation, and then there's defamation per se. What's the difference between the two? First, defamation is basically making a false statement about another person. So let's say I have a kid in school and the teacher is not a very nice teacher, and I go around saying, "Oh, the teacher is not very nice." Next thing you know, the teacher is not getting any students in her class. They're writing letters saying, "We don't want my kid to have that teacher because that teacher is just known for having a bad reputation. Not that she's doing anything illegal. She's just not a nice person." Anyway, it winds up, for some reason or another, this is just a crazy hypothetical, she winds up getting fired. So then at that point, she says, "Well, my name has been completely ruined. I've been defamed." She would have to prove that the allegations that were made about her were untrue, but she would also have to prove damages. She would have to show that she was damaged by it. And that's always the more difficult part in a lawsuit. Now, in my case, I said she got fired because of it. Now, in that case, she probably would have an easier time proving damages. But if there was a situation where she didn't get fired and she still kept her job, but she still claimed defamation, that would be more difficult for her to prove damages. So at the end of the day, it all depends upon their ability to first prove that they were actually defamed because it was untrue, and two, that they would be able to prove damages. Now, the difference between defamation and defamation per se. Defamation per se are untrue statements that are on their face so egregious, they're such horribly made statements that you do not have to prove damages. You still have to prove that the statements that were made against you were untrue. Truth is a defense to a claim for defamation. So basically, there are four categories of cases that fall into the defamation per se. One is a person is involved in criminal activity. The second is that the person has a loathsome, contagious, or infectious disease, indication that a person was unchaste or engaged in sexual misconduct, indications that a person was involved in behavior incompatible with the proper conduct of his business, trade, or profession. So I'm not going to get into the other three, but for the purposes of what we're talking about today, indication that a person was involved in criminal activity. Now, that letter indicated that the banner was going to say not just that Ken Griffin lied, but that Ken Griffin lied under oath. Lying under oath is a form of criminal activity. So because of that, that would be considered defamation per se. So arguably, if the banner said something like Ken Griffin is a liar, Ken Griffin is known to lie. Ken Griffin lies. Allegedly, Ken Griffin lies. Something like that. Ken Griffin is not a nice guy, or another, creative word you might want to use on a banner. Those things would technically and arguably not be considered criminal activity. Of course, lying is not criminal activity. Whether you feel somebody is a liar or not has nothing to do with a crime that they may have committed. You just may think they're a liar. That's your opinion, and you're entitled to your opinion, and you can state it any which way you want. So that's basically the situation with the batter. Now, in general, when you're a content creator and you go onto YouTube and you have a large audience, you really want to be careful how you couch terms about individuals. You really want to be careful. Again, if you're stating an opinion like X person is a jerk or X person is a liar, those types of statements, again, those are your opinion. They're going to be hard for them to prove that that's going to have an impact overall on their reputation. But if you go out and say one of these things, like so-and-so is not only a liar, but I know for a fact, even though you don't know for a fact, I know for a fact, or from something I read on the internet, that not only is he a liar, but he's also committing crimes. He's done insider trading, or he's done something that is in relation to lying under oath. Those things are very dangerous to say, especially if you have a large audience. Remember, they don't have to prove damages. So ultimately, the court would say, well, only one person heard it, so his damages would be limited. But if they say, well, this statement was made on a channel that has 350,000 subscribers, and it was heard by a lot of people, and it really impacted his credibility and his ability to act as a person in his business, then that person can be in some significant trouble. So you really have to be careful in how you say things on the internet. I know in the heat of the moment, a lot of the times, there's a lot of knee-jerk reaction to say and post things. And as an individual, like an individual person on Twitter, if you're out there and you make a statement, again, your reach may not be very large. I still wouldn't do it. I would recommend against it. If I was actually, representing people, I would say, you're better to err on the side of caution rather than to say whatever you want on the internet, because you never know. A lot of people are very litigious. These people have a lot of money, and they're not afraid to just say, oh, let's sue everybody. So just be careful in that regard. So that's really what I wanted to talk about in regards to the defamation situation. I hope that helps. That's my opinion on it. None of this should constitute legal advice. But that is definitely my opinion on defamation. So be careful with that, and just be a little more artful in how you make your statements about people. Next thing I want to talk about is credibility. Credibility is an important thing, and I've noticed that come up lately, especially in regards to certain documents that are posted on the internet. I want to go and show you guys something that I had seen on another page. Just give me 1 second to pull it up for you. And I'm not picking on Trey. I love him, and this was not originally posted on his page. I had seen it on all over Twitter, but I just know that this is where it's easily accessible. So this was posted the other day, and stuff like this. This is where I saw people commenting on this post, saying things like, oh, I don't know if this looks legit. I don't know if it's real. Can anyone prove that this is real? Where is this from? And again, I have to admit, I had the same, nerves and suspicions about it, because, as a lawyer, I know what a complaint looks like. And a complaint, this is basically broken up into paragraphs like a complaint. But the problem is, look at the numbering. You have paragraph 220 here, then it goes to paragraph 12, then it goes to paragraph 15, 16, which is in sequential order, but then it jumps from paragraph 16 to 140. So when you look at something like this, you say to yourself, wait a minute, how is this legitimate? This doesn't look real. The numbering is all off. Everything is all over the place. So again, I went on to Pacer and I checked the Robinhood complaint, and I did find that all of these paragraphs are indeed in the complaint. So this is a verified document. This is not a fake. This is real. All of these allegations are set forth in the actual complaint. But the problem is, you don't want to give, the people that are against us ammunition to say, oh, they're just they're throwing, whatever sticks up against, and to see whatever sticks up against the wall. They're posting every little document that they find on the internet. They're not verifying it. Look at this one. It doesn't make any sense. Now, this one was able to be verified, but you really, really, really want to be careful. Presentation matters. It really does. I know that another person had said that presentation really doesn't matter, but I disagree with that. I think that in order to be credible, even on the internet and in the court of public opinion, you really want to make sure that the evidence that you present in support of your thesis is not only verified through due diligence, but also is presented in a way that makes it look credible. So I would just say to be careful on that. I'm not trying to say that, you have to go completely out of your way, but again, if you really want to establish an argument, especially as a lawyer in court, I would not show a judge a document like this. This would be completely, torn apart by an opposing attorney. So this would be not something that I would rely upon. So, and I know, again, this is not the courts, this is the internet, and maybe I'm thinking more than it has to be, but in reality, I really do feel that credibility goes a long way. And I think that, watching out what we post is important. All right, so the next thing I want to talk about today is where are we in this litigation? Where are we in regards to In Re January 2021 short squeeze trading litigation? So for a second, let's step back. All right, so what happened so far? So we know that 2 complaints were filed, okay? We know for a fact that 2 complaints were filed. The first complaint that was filed against Robinhood directly, all right? So this is the first complaint. It was filed against Robinhood, and it sets forth a number of allegations: negligence, gross negligence, breach of fiduciary duty, breach of implied duty of care, breach of implied covenants of good faith and fair dealing, tortious interference with contract and business relationships, and civil conspiracy. I will do a separate video addressing every single one of these counts, but just for the purposes of today, because I'm going to be getting into Rule 12, I just want to show you that there is a complaint that has been filed. That is step 1. The plaintiff files a complaint. There was a second complaint filed, and that complaint was filed against Robinhood, market makers, various other brokerages, and Citadel. And the allegation in this case is a violation of the Antitrust Act, the Sherman Antitrust Act, violation of 15 USC Section 1, and it also alleges a conspiracy. Now, this involves a bunch of players. So now there's 2 complaints. So what happens after a complaint is filed? Under Rule 12 of the Federal Rules of Procedure, when a defendant receives a complaint, they have 2 choices. The first choice is to immediately serve what's called an answer. And an answer is a document that basically goes through each and every one of the allegations and essentially just denies every single one of them and sets forth a bunch of defenses that they want to, that they're going to raise throughout the course of the trial. However, there are certain defenses that they have to raise prior to filing an answer. And if they do want to file one of those motions, they have to do it before they file an answer. And that is called a 12B6 or a 12B motion. Now, under 12B, there are 7 defenses that they can raise prior to filing an answer: lack of matter subject jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted, and failure to join a party. So I'm not going to go through all 7 of these because they only are raising one. They made a Rule 12B6 motion. They're stating in their motion that there is a failure to state a claim upon which can be granted. Now, what does that mean? That means that even assuming if all of the statements that are made in the complaint are true, that even if they are 100% true statements, they are still not responsible for what they are being claimed to be responsible for. So that's important to note. Remember, the allegations that are set forth in a complaint do not have to be proven. They're just allegations at this point. So their answer, their motion has to show the court that, listen, Judge, even if everything that they said is true, it's all 100% true. But notwithstanding that, none of it adds up to a conspiracy, or none of it adds up to negligence. And that's where we are right now in these proceedings. Now, there's, like I said, there's two different complaints. One is an antitrust complaint, and the second one is the Robinhood complaint. Now, in terms of the antitrust complaint, Citadel has already filed its motion to dismiss. Here's their motion to dismiss right here. Defendant's motion to dismiss the complaint. They've already filed their motion to dismiss. Now, I'm going to take a deep dive into the motion to dismiss tomorrow and really, go through it. I'm going to highlight the important parts, and I'll let you know what they're arguing and why they believe that they have failed to state a cause of action. The plaintiff is allowed, after the motion is filed, to submit what's called an opposition papers. And here is the opposition papers. So here's the antitrust plaintiff's motion in opposition, and here is the defendant's motion to dismiss for failure to state a cause of action. So now we have both documents. We have the motion, and then we have the opposition papers. Now, again, tomorrow I'm going to go through these very, very in great detail. But what we're waiting for now are two things. One, we're waiting for the motion, again, the motion to dismiss from Robinhood. And then we're waiting for also the reply papers in regards to this motion and this opposition. So usually the way it works is first a motion is filed by the defendant, then the plaintiff gets an opportunity to file what's called opposition papers, and then the defendant gets to respond to that opposition in what's called a reply. Once all three of those documents are submitted to the court, then it takes about 60 to 90 days for a decision to be rendered on the motion to dismiss. If the motion to dismiss is granted by the court, that's it, the case is over. If the motion to dismiss is denied, then it would move on to the next phase, which would be discovery. And then there's some other motion practice that can take place, but we'll get into that as the case progresses. So right now, the Robinhood motion to dismiss has to be filed by October 15, 2021. Then the plaintiff will have until November 5th, 2021 to put in opposition, and then the defendant will have until November 19, 2021 to put in the reply papers. So let's assume there's no extensions granted. The papers would be all submitted by November 19th. And then if you figure 3 months from then, November, December, January, February, you're looking at about February for that decision to come out. And then in regards to the antitrust motion, which is the Citadel motion, the reply papers that I said are missing, those are due October 5th. So if all those papers are submitted by October 5th, you're looking at a decision definitely before Christmas time in regards to the motion to dismiss on the antitrust aspect against Citadel and the other parties. So that's where we are right now. We are in the motion phase of everything. The last documents that were updated were on Thursday, September 23rd. I've already gone over those documents and shown you guys that was an update. That was this order setting forth the motion schedule. That was the most recent document that is uploaded into the PACER system. I have an alert set, so I'm always going to get the alerts right away the second they pop up. And as soon as the documents pop up, I'm going to go through them right away. And if they're really important, I'll do a live stream. Otherwise, I'll definitely have the video up within the first couple of hours of reviewing the documents, or if anything, I'll highlight the important pages and post them on my Twitter account. But for now, that's basically what I wanted to get into today. I just wanted to give you guys a little brief rundown on where we are. Tomorrow, we're going to really go in and see what their arguments are in that motion to dismiss, to see how they're trying to argue out of the causes of action that have been alleged against them. So for now, guys, just do me a favor. If you are enjoying learning about the legal aspect of this, and I really think it's important to learn not only the financial aspect of it, but also the legal aspect of it, because everything's sort of, intertwined at this point. I'm sure you guys are figuring that out. And I think it's important that, everyone keeps, up to date and knowledgeable on these issues. So, you know, if you can spread the word, let your followers know, let your friends know, join the Twitter, subscribe to the YouTube channel, hit the like button if you like, you know, the videos. And also, if you have any questions or want me to discuss any specific topics, it doesn't necessarily have to be related to the motion. It could be anything in regards to what's going on with AMC in general or GME. You know, keep on doing what you guys are doing out there. Just be careful with what you're doing, and just be careful with what you're saying, because some of it can get you into a little bit of trouble. So just, you know, be mindful of that. One last thing, none of the information contained in this video should be constituted as legal advice. And for now, I hope everyone has a great night. And until I talk to you guys tomorrow, the Lawyer of the Apes is adjourned.